Thank you, Madam President. I beg to move that a bill entitled An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority, and connected matters be now read a second time. Madam President, I consider this both an honor and a privilege to be permitted to address members of this august Senate with respect to the Cannabis Control Bill 2020. And may I, before I embark on the substantive matters before us, say a few prefatory words. I wish, first of all, Madam President, to acknowledge the work of the chairman of the Joint Select Committee, my predecessor in office, the Honourable Faris Al-Rawi, Member of Parliament. And in particular, his winding up debate in the House of Representatives on the 29th of April, 2022 on this bill. I wish also to highlight, Madam President, that contributing to the considerable work which we are engaged on today and which has taken the time of the other House are the reports of the Joint Select Committees appointed to consider and report on the Cannabis Control Bill 2020, which report acknowledges the agreement of both sides in the House of Representatives, and I look forward to that continued commitment to purpose from the other side this morning. I would wish to highlight, with respect to the bill before us this morning, Madam President, certain aspects of that bill which I emphasize must bear remembering and underline. The first being the recognition in that bill of what my predecessor in office referred to as the local content. The bill recognizes that there is a significant involvement and endeavor of the members of this community of Trinidad and Tobago, the national community, and it therefore gives recognition as we move to regularize the handling of cannabis to the local content that must be acknowledged throughout, and to reap the benefits of the decriminalization as we now move to the regulated use, which I will return to in the substantive comments on the bill. Madam Speaker, I also wish to acknowledge the work not only of my predecessor in office, but the Honourable Minister of National Security, the Honourable Mr. Senator Hines, who have walked the talk throughout Trinidad and Tobago, participating with and engaging the people of Trinidad and Tobago in lively debate and public consultation on the work of the Joint Select Committee and its report with respect to this bill. The expertise of personnel I also wish to draw on and to recognize in the contributions which have been made to the content of this bill, and I particularly wish to acknowledge the work of those experts, in particular Mr. Marcus Ramkisoon, to whose report I will return in due course, and I thank him here for the record. Madam Speaker, Madam President, the bill which is before us today is a development on the earlier passage of the amendment to the Dangerous Drugs Act, Amendment Act 2019, which decriminalized certain aspects of the use of the drug, which is commonly known as marijuana, but now properly and comprehensively defined in the bill before us as cannabis. That decriminalization has decriminalized certain quantities of cannabis and cannabis resin, has prohibited the use of the substance in public spaces, in educational institutions, and places of work, among others. 2 years after the enactment of the Act, numerous positive societal and legal effects of the decriminalization of cannabis, possession, use, and personal cultivation in Trinidad and Tobago have been identified. And I've already acknowledged that there have been serious consultations by those who have worked on this bill with the stakeholders in the community, which led to the passage of the bill in the lower house. What we are seeking to do today, Madam President, is to move beyond, and positively to move beyond decriminalization, and to provide for the regulatory control of the handling of cannabis for certain purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority and connected matters. And we are specifically concerned to regulate the use and handling so that we can reap the benefits, societal, legal, and economic, of the proper use, cultivation, and sale, and medicinal and religious use of the cannabis and its related products. The bill creates an authority which establishes a board, Madam President, whose members are appointed by the President and whose functions include the granting, amending, suspending, revoking, or cancelling of licenses, inspecting, monitoring, and assessing the handling of cannabis, taking enforcement measures in the event of non-compliance, and establishing and maintaining a register of licenses and other connected functions. It considers medicinal cannabis, allowing a medical practitioner to prescribe its use with specific dose limitation and a pharmacist to dispense same. Medical marijuana can help patients suffering from various illnesses, such as cancer and epilepsy being some of the harshest diseases. Due to the new medical advances, cannabis has been proven to be something of a medical miracle for epilepsy patients across the world. Having done that research, and I want to return when I speak a little further on to the issue of research, why should we then continue to criminalize people who are able to effectively and safely use cannabis to alleviate the symptoms of long-term health conditions? By analogy, Madam President, cannabis was decriminalized in 2015 in Jamaica, and for a small country, Jamaica has made significant strides in building an industry in a short amount of time. Jamaica in 2018 opened its first medical cannabis at Kaya Farms, and there are now medicinal dispensaries throughout the island. Madam President, I would like to take members, with your leave, through the clauses of the bill before us, and in that regard, I would invite members to follow me as I go through the bill essentials, which I believe all members have before them. Clause 4 of the bill establishes a body corporate known as the Trinidad and Tobago Cannabis Licensing Authority, which would be responsible for the regulatory control of the handling of cannabis under this bill, vested with such powers as are necessary or expedient for the performance of its functions. Clause 5 of the bill establishes the functions of the authority, and in particular, I wish to emphasize, among others, because no one should be left out, but I consider it, in my respectful opinion, important to emphasize sections 5.1J and 5.3B. Why do I emphasize that? Section 5.1J says that the function of the authority is J, to provide for the distribution of educational materials and the conduct of training programs in relation to the development and use of cannabis and the development of the cannabis industry. And section 5.3B tells us that in the performance of its functions, the authority shall be facilitate scientific research in respect of cannabis and, where applicable, apply the results of such research in the development of the cannabis industry. I consider these particular sections of Section 5 of the bill under consideration to be important, Madam Speaker, because, Madam President, I beg your pardon, because it is important to recognize that in any developing society, and I use the word developing synonymously with evolving, and I use it evolving deliberately because I abhor the use of terms lesser developed and more developed. We are all one humankind, and we progress through our deliberate efforts to improve our lot for ourselves and our fellow citizens. And I consider the research capacity, which is contemplated by this bill to be bestowed on the authority, to be important for the simple reason that we recognize as we pass this bill, I hope, that there is work to be done by the authority that involves research that will continue to seek out and identify the positive attributes of this particular cannabis and to be able to deploy it as we continue to apply the provisions of the bill for the better use of cannabis in educational institutions, in medicinal institutions, and also in economic activity. I would, just for a moment, hark back to, and we are all, as students of history, we are all cognizant of the days of prohibition in the United States of America. There was a point at which alcohol was prohibited, but by dint of human endeavor and our efforts to improve our lot, we have seen that we move beyond prohibition, as we are now moving beyond decriminalization with respect to cannabis. And what we are seeking to do is to regulate its use, to deepen our research of the potential benefits which we can gain from its use, and thereby to develop our society for the benefit of all of us. So that is my emphasis, without decrying or diminishing the value of any of the other functions of the authority. Clause 6 of the bill, Madam President, provides for the appointment of a 9-member board of directors of the authority, and we are reminded that that board shall be appointed by the President from among persons who are skilled and resourced and experienced in very significant disciplines. And they are listed there in the bill essentials, which are before members of Parliament, members of this august House, the Senate. I will not read them all, but again I emphasize what I consider to be some of the areas that are of significance in terms of the skill set that is being brought to the authority as the members of the board are to be appointed. So we have persons versed in finance and accounting, we have persons versed in medicine, persons versed in scientific research, law enforcement, education, and of course, drug rehabilitation. It speaks, Madam President, to the seriousness with which this government undertakes to commit the authority to a task that will be fully skilled, very capable, and therefore able to respond to the needs of the society and to the demands that are being brought upon the authority as it progresses. Clause 6, of course, provides for the remuneration of the members of the board, and that remuneration shall be reviewed by the Salaries Review Commission. Revocation of appointment is dealt with in Clause 8, and the instances where a member of the board shall have his or her appointment revoked, those instances are set out in Clause 8. I need not belabor them. They are not dissimilar to many of the other bases on which other boards and indeed even members of the judiciary will find themselves disqualified and or have their appointments revoked in the case of their inability to continue to discharge the trust which this Senate, which this Parliament is vesting in them. Immunity of members, we have to recognize, Madam Speaker, that as we embark upon our myriad responsibilities in the authority given to us by different statutes, we are human. We will make mistakes, but once those mistakes are made in good faith and in earnest purpose and the desire for the betterment of our fellow citizens, we have to permit a certain degree of latitude to our fellow citizens who take on the heavy responsibility of the functions of the board to make those mistakes without having to be hauled before courts or indeed the police for misfeasance or acts that do not amount to misfeasance. So we allow, by Clause 10 of the bill, a degree of personal immunity to members of the board, and I think that that is to be commended, and I commend that to members of this House. The quorum and decisions of the board, of course, will have to be...
Attorney General.
Honourable President, just a point of clarification, Honourable Attorney General, through the Honourable Speaker, President rather. In Clause 10, the term gross negligence as opposed to negligence. I was wondering if you could clarify why we inserted this concept of gross. Because I'm looking at previous legislation as it relates to immunity, and there's no suggestion of gross. So I just want to get some clarification as to the thinking of the government as it relates to this new concept that has been inserted here. To the Honourable President.
Thank you, Senator Mark. And it is never for me to say that I would suggest that you speak too softly. So if I didn't hear you fully, I attribute it to the mask which shrouds your normal delivery. So if I did not hear you fully, please forgive me. If I understand you correctly, you are concerned with the introduction of the qualifying word gross to qualify the word negligence, and you are concerned to appreciate why is that qualification introduced to the word negligence, correct? Thank you. Well, it goes to what I was saying earlier, Senator Mark. We have to allow human error to be committed unless it is of a quality and comes with an intent that takes it beyond the realm of ordinary human error. I can be driving a car down the road tomorrow and my young child might be in the passenger seat or even behind me, in the seat behind me, and I hear a sound which alarms me, and I turn back instinctively as a parent to respond to that sound, and I hit the car in front of me. That is negligence, but that is not gross negligence. So we have to permit a degree of latitude to the driver of this vehicle, the authority, the members of the board, to recognize that some error will be permitted without them being held personally accountable. Otherwise, what we will find, Senator, is that we will be unable to recruit talented, committed patriots to serve on this authority. Have I addressed your concern sufficiently, Senator?
Through the Honourable President, that at the committee stage, Honourable Attorney General, we will pursue that matter a little more. Okay? Thanks very much for your clarification.
Madam President, with your leave, may I continue? Thank you. So I was at clause 10, and I was speaking to the immunity, and I think that I have addressed that sufficiently. I had moved to clause 12, quorum and decisions of the board. We have clause 13, which allows the board to appoint committees, because of course the members of the board can't do all the work, so they will appoint committees to do further work in the interest of moving the authority's business along. Disclosure of interest. Of course, we recognize that those persons who are charged with regulating the handling, cultivation, use, handling is a complete term that includes cultivation, use, transporting, etc. Those persons must not have an interest in the very industry that they are regulating, and therefore if there is any suggestion known to them that they have an interest, they are not allowed to participate in the affairs of the board. They must disclose that interest, and you will see in further sessions, members of this honorable and august Senate, that there are bases on which they can be disqualified for having an interest in the very industry that they are regulating. And of course, clause 15, there must be, in my respectful submission, and the drafters of this clause in their wisdom have introduced, the provision for, there must be provision for a chief executive officer, which will allow a person of sufficient experience in finance, management, or accounting to be responsible for the daily management of the authority, subject, of course, to the directions of the board. And that person, the CEO, also is prohibited from having an interest in the very industry which he is regulating and is the chief executive officer of. Clause 16 similarly provides for the board of the authority to be assisted and supported by the staff of the authority, and we see also that the authority can engage an expert, an advisor, or consultant on contract to assist in conducting its regulatory responsibilities. Those persons will also be subject to the disclosure requirements of the Act, and failing the appropriate disclosure are liable to be committed on summary conviction. Of course, clause 17, I move next. The bill empowers the board to delegate certain of its functions and that of the CEO or designated officer by written instrument as necessary. The written instrument being necessary to ensure clarity in the fact of designation and delegation of authority. Confidentiality, we recognize in the holistic view of the bill before us, that there are a number of different facets to the functioning of the authority. That is to say, it has medicinal purposes, it has religious purposes, and other purposes. There will be medical doctors involved, there will be patients involved, and therefore, within reason, the affairs of the business of the board must be treated in a confidential manner, subject, of course, to law. Clause 20 of the bill establishes the Trinidad and Tobago Cannabis Licensing Authority Fund, which shall comprise monies from appropriations by Parliament, fees, etc. And I would recommend for the attention of members the fact that when you look at the remit that is allowed to the authority to charge fees, I compliment that fact for the very reason that we have to ensure that this authority will be self-sustaining, it will be earning fees from the different work that it does, and it will not have to turn to the consolidated fund, which is one of the sources of its revenue for its continual and constant survival. The authority is strictly prohibited from borrowing any sums or accepting or receiving any money by way of grant or donation from any person or entity regulated by the authority, and I think that that is self-explicit, speaks for itself. The application of the fund is provided for Clause 21 and tells us the instances in which monies contained in the fund may be applied in defraying the authority's expenses. The authority must keep proper accounts, and we see that Clause 24 of the bill tells us the manner of the accounting that must be done. The audit of the accounts is established by Section 25. These are public accounts as stipulated under Section 116 of the Constitution, and once the accounts of the authority have been audited, the Auditor General must submit his report in accordance with Section 116 of the Constitution and simultaneously forward a copy of the report to the Minister. There is, of course, the power to borrow, but I've already touched on that. Clause 26, power to invest, and that speaks to the fact that the authority is recognized as a body that must be self-sustaining, so it gives, Clause 27 gives power to the authority to invest monies in security not immediately required to be expended to meet any obligations. Clause 28 exempts the authority and its assets from taxation of every kind and description. That is self-explicit and set out in Clause 28 of the bill, and we do that, we recommend that, particularly at this inception period where we are embarking on a new endeavor, a new industry that must be given the support that it can get from the society for the benefits that it will bring to the society at the societal level, at the medicinal level, and the economic level. The authority is required by Clause 29 to submit annually to Parliament a report of its activities during that calendar year within 3 months after the end of each calendar year. So we here, when we pass this bill, as I anticipate, optimistically we shall have the confidence of knowing that we are entrusted with an oversight of the functioning of the authority, which must come back to us annually and produce a report for our review, our criticism, our support, or otherwise. Licenses are varied and several. Clause 30. A cultivator's license, a research and development license, a laboratory license, a processor license, a retail distributor license, an import license, an export license, a transport license. And I have no doubt we will hear more in due course from other members of this House who will speak to the medicinal import of this authority and the quality of health that will be improved by the appropriate licensing regime that will be provided for. Similarly, we will hear more on the import and export licenses and the revenue attraction that will be permitted. Madam President, I believe one of our members wishes to ask a question of me.
Senator Mark.
Let me just
So, Senator Mark, I remind you that...
Yes, it's just a clarification.
Yeah.
But I don't want to come across muffled, that's all. Honourable Attorney General, through the Honourable President, just wanted you to clarify in terms of the cultivator license, there is wholesale in terms of his product or plant. I was just wondering if we want a level playing field, why the cultivator cannot engage in retailing. So right now, according to 29A, he's only confined to wholesaling. So I'm asking your good self if the government would consider amending this part to allow retailing to take place in this particular area.
Thank you, Senator Mark. I wonder whether you would be kind enough, Senator Mark, to permit me to, within the allotted time that is allocated to me, to make this opening statement as I pilot the bill. I wonder whether, given the experience that you have sitting in that other place, whether you would permit me to complete my pilot. The question is a valid question, but if you would, I would like to complete the pilot, and we can address those matters at the appropriate point. Thank you very much. So, Madam President, with your leave, I had moved to the power to borrow. I had touched on that, the power to invest. I had touched on that exemption from taxes annual report, and I had engaged the licenses at the point at which, in another place, I would say my learned friend, Mr. Mark, Senator Mark, rose to interrogate me. If I may move on, I was about to touch on the fact that we also have to recognize that cannabis in other societies as well as our own has an almost sacred and revered status. And we recognize that cannabis should be allowed under license to be used for religious purposes, and we make provision for that in the cultivation, in the licenses that are to be issued under the bill that we are considering. Eligibility for a license is provided for at Clause 31. You must be a citizen of Trinidad and Tobago, a permanent resident of Trinidad and Tobago, or a citizen of a CARICOM member state other than Trinidad and Tobago. Ample provision is made there, and I commend that to members. And of course, there is provision for the controller of the religious organizations and applications for licenses being properly regulated. That is spelled out in quite a lot of detail, and I am sure we will engage in conversations on that. Clause 32 provides for the authority to request further information relative to the application from an applicant for a license. And once the license is granted, the authority is empowered to publish in the Gazette at least twice during a period of 2 weeks in 2 daily newspapers in circulation, relevant information for the attention of members of the citizenry of Trinidad and Tobago with respect to licenses that are applied for, granted, and you will see further on in the bill, licenses that are either suspended or revoked. So that the intention of this legislation in its nascent stage, where we are introducing this for the first time for the development of a serious industry, is that throughout the process must be transparent and the public must be allowed to follow the development of the industry as it regulates itself and is regulated by the authority. Madam President, we move on. We look at clauses 34 through to 47, the deal 48, the deal with details of the licenses. We look at clauses 49 through to 53, which deal with terms and conditions of licenses. That is all spelled out in detail. When we get to part 5 of the bill, we deal with medical cannabis, and this is something which I hope in due course the Minister of Health will assist us with so that we can better understand the assurances that we will be receiving from those who are empowered to regulate the medical health of this country. Clauses 43, 44, through to 47 deal with medical cannabis. And then we go to Part 6, cannabis for religious purposes. I have touched on that, and we have seen that clauses 48 through to 51 deal with cannabis for religious purposes, recognizing the very, I say without meaning anything other than the use of the word, the sacred use to which cannabis has been used and put to good use throughout not just Trinidad and Tobago, but throughout the Caribbean. And we respect that, and we give cognizance to that. We have a register system, Madam President, clauses 52 to 59, so that the establishment and maintenance of registers by the authority in respect of each type of license is to be maintained by the Chief Executive Officer and the authority. And again, that speaks to the system of transparency that this bill envisages, so that throughout, members of the public will be aware of what is being done under the auspices of this bill and what is being regulated under the watchful eye of the authority, the Chief Executive Officer, the supervisory authority, and that is an important point. In its financial activity, we will see when we look at the bill in its individual clauses that the supervisory authority of the Financial Intelligence Unit of Trinidad and Tobago has a supervisory function to ensure that the use to which this bill is put in terms of its use and the money that it earns is not used for illicit or illegal purposes. A very important provision in my respectful view in the bill. And we see, Madam President, Part 8 of the bill deals with inspections throughout the life of the regulated industry. There will be inspectors who will be enabled to inspect the use to which the cannabis is being put, including the power to enter premises. Inspectors will have the power to enter premises specified in a license other than a dwelling house without a warrant, and that is to ensure that no abuse is made of the regulation that this bill is asking this House to approve. Clause 64 provides for the powers of inspectors. These powers include, as we have set out here, power to enter premises, to verify compliance with the Act, to take photographs, to seize anything which may be of evidential value for the prosecution of an offense, and to direct the temporary suspension of any activity which the inspector, he or she, reasonably believes to be in contravention of the Act. And 65, Clause 65 of the bill prescribes for the issuing of a warrant by a magistrate where there are reasonable grounds for believing that an offense under the proposed act has been or is about to be committed in any dwelling house. And then there are the miscellaneous provisions of the act, of the bill, Madam President, 66 through to 69. And I emphasize, without delimiting or limiting the importance of clauses 66 through to 69, I emphasize clause 69, which tells us that the authority will have the power to provide for and to make regulations. And that will be an important part of the functioning of the authority, to provide for regulations, because the bill gives the enabling framework within which the regulation is to take effect, but it will be the responsibility of the board, as it speaks to the discharge of its functions, to be able to regulate and to prescribe for regulation by well-drafted regulations done in consultation with all relevant stakeholders. Madam President, with respect, as we move beyond the clauses of the bill, I will say a little bit about the benefits to the society which this bill intends to introduce, and what we have by way of benefits, Madam President. We have to take note immediately that given the decriminalization that has been introduced by the amendment to the Dangerous Drugs Act, there has been a decrease in dependency on the illicit market, as individuals are now allowed to cultivate their personal supply needs. There is also less risk-taking behavior by consumers, and the statistics have shown a decrease of foot traffic in the areas known for illicit cannabis sales, where other aspects of criminality often exist. So what we are witnessing already in the non-regulated reality that has been introduced by the mere fact of decriminalization is that we are separating the everyday use of cannabis from the areas that involve criminal activity, and therefore we are saving members of our society, valuable members of our society, from the negative stigmatization that has been traditionally associated with cannabis, and criminalization, and encouraging ourselves to have a more positive outlook on cannabis use in the community, less fear by consumers of engaging positively in academic or work pursuits, more interest in the plant as medicine, and increased willingness to learn about the substance, and have already emphasized the important task of research that is going to be encouraged under this bill. Very significantly, Madam President, there will be, and already the records are showing, less separation of families, as the prevalence of cannabis use in Trinidad and Tobago is substantial, and prior to the amendments of the law, which has already been introduced in 2019, parents found in possession of cannabis could have been separated from their children by the state, leading to more dysfunctional and broken family structures. The amended law therefore allows more families to stay together, and the bill that we have under consideration now is looking to provide for a more holistic environment in which we can separate ourselves from this scourge that has afflicted families, having persons, fathers and mothers, put into our prisons and exposed to the more hardened elements of the prison population, separated from their children for having, to use a colloquial expression, one or two spliffs in their possession. That is something we want to move beyond as we embrace the value inherent in every human being, mother and child, in this society. There is an ever-increasing emerging market and demand for agricultural supplies, and therefore supporting new and existing agricultural business, promoting the emergence of new specialist and specialized cannabis cultivation and consumption supply stores, distributors, and even local manufacturers of specialized products, thereby positively affecting economic diversification. And this is where the local content, which has been spoken to very eloquently by my predecessor in the lower house, the local content that is recognized will be given to the investment by members of this community to grow and build an industry out of a plant that can bring significant economic benefits, properly regulated, to all of the people of this country, and I commend it. We have, as one of the other benefits, cultivation for personal use, increased interest in horticulture and agriculture, savings on regular cannabis expenditure by consumers, development of local cannabis genetics, access to better and safer quality cannabis. We also have the positive legal effects of the legislation, Madam President. Already we have the drastic decrease in cannabis arrests, as the vast majority of arrests prior to the amendments becoming enacted were for cannabis possession of less than 100 grams. That has been on the decrease, and the statistics which the Joint Select Committees have been able to obtain from the judiciary speak to almost a 70% decrease in the convictions that are reaching the courts. We speak as well, Madam President, to having to spend a lot less taxpayer dollars towards processing and incarcerating individuals for cannabis possession of less than 100 grams, and exposing persons who are not criminals to the hardened elements within the criminal environment of our prisons with the known, obvious, and almost ineluctable results that incarceration in our prisons bring about. The law has reflected considerations for most of the discussions, and I commend the members of the Joint Select Committee under the chairmanship of my predecessor, Honourable Al-Rawi, for the discussions and points arising from public stakeholder and expert consultations with the legalized possession limit, cultivation for personal use limit, legalized use in private spaces, and expunging of the offences from the criminal records of past offenders. Fixed penalty notices for certain offences will bring revenue to the national purse, as opposed to creating expenditure by arrest arrest, prosecution, and incarceration. There are also benefits to the criminal justice system. The drastic decrease in traffic, and by traffic I mean human traffic of cases at the magistrates' courts, decreasing backlog and allowing the courts to concentrate on more substantive matters engaging the control of criminal activity in the society.
Attorney General, you have 5 more minutes.
Thank you very much, Madam President. I may have to ask Mr. Mark for a little bit more of his time. Thank you. Madam President, that brings me to the conclusion almost of my submission today, to make the point that what we are looking to embrace in our society is a truism. That is to say, law does not operate in a vacuum, statute law less so. A statute is intended to guide and regulate the conduct and affirm and regulate the conduct of those to whom it is addressed, its content taken in recognition of the cultural, economic, political, and social conditions of the society within which it is intended to operate. And I dare say, Madam President, that with the creativity, the entrepreneurial skill, and the vast talent that is available in the society or national community of Trinidad and Tobago, we can look forward to a thriving, rich, enduring industry. Madam President, I beg to move.
Honourable Senators, I shall now propose the question for debate.